Hi, this is Kathy Pfeffer-Hahn, and I'm asking you today, which would you consider? Gifting your money away before your passing or waiting until you go? The decision to gift your inheritance before your death or retain it after depends on various factors, including individual preferences and family dynamics. Gifting during your lifetime can foster a sense of financial responsibility among your heirs and allow for a more active guidance and asset management. It may also have the potential tax benefits while granting you the satisfaction of witnessing the positive impact of your legacy. However, keeping the inheritance until after your death can serve as a financial safety net for unforeseen emergencies, maintaining a structured distribution process, and minimize conflicts among beneficiaries. The choice between these options ultimately hinges on one's unique circumstances and goals, striking a balance between financial security and familial considerations, and consultation with financial and legal professionals. As you start to consider your passing and what you'll do with your money, ask yourself, do I want to share the wealth now or after I'm gone? The money you give may be taxed with either estate taxes or inheritance tax, but most people don't pay because the deceased or decedent, that's the person who died, has to have a net worth of at least $12.92 million. The good news is that most states don't charge these taxes any longer, but these estate taxes are incurred in the state where the decedent lived at the time of their death. The following states do have estate taxes: Washington, Oregon, Minnesota, Illinois, Vermont, Maine, Rhode Island, Connecticut, and DC, while Maryland charges both estate and inheritance taxes. Inheritance taxes are charged based on where the recipient lives after receiving the inheritance. The states with just an inheritance tax are Pennsylvania, Kentucky, Iowa, Nebraska, and New Jersey. I'm not going to go into all the details here because most of us won't have to worry about that $12.92 million cap, but if you do, please get financial advice from a fiduciary advisor. So what is an estate tax? It's based on the current fair market value of the decedent's assets. This is not to be confused with the value of the property when it was originally purchased. This could include bank accounts, investments, retirement plans, artwork, jewelry, businesses, household items, vehicles, and any debt that's owed to the decedent. These estate taxes do not apply to the surviving spouse, as there is an unlimited marital deduction allowed. You can give them any amount that you desire without being taxed. If someone inherits money or assets that they don't want, they're welcome to decline it through a waiver, because you're not required to take the money. In that case, another heir would be named as the beneficiary or recipient of the estate. Gift taxes are interesting. The IRS says that a gift tax is a tax on the transfer of property from one individual to another while receiving nothing in return. In 2023, the amount that you can give away tax-free is $17,000 per person. You can do this for as many people as you'd like, as long as no one person receives more than $17,000. It can be given to them directly, or it can be put into a trust that you set up for them. Additionally, your spouse can also give up to $17,000 in gifts, including to the same people that you've gifted money to, and that means they could get a total of $34,000 each year. The gift tax does not have to be money gifted to you. It could be property or even use of that property. If you make an interest-free loan or reduced dollar amount loan to someone, that could be considered a gift as well. And finally, if you sell something at less than full market value to another person, then the person that you're giving it to is receiving a gift. If you allow your rental home to be used by your children, sell someone your $30,000 car for only $20,000, or buy them a car outright, all of these would count as gifts that you've given. And these gifts are not limited to your kids or even your family. It could be anyone that you want to gift an item or money to. These gifts are not tax deductible like gifts that you may give to a charity. Those would have to go to a 501c3 status charitable contribution. If you're giving more than the $17,000 or $34,000 if you're married, you'll owe taxes on any amount gifted over those caps. And no matter the amount received by the recipient, you'll owe no taxes on a gift that you're giving them. The good news here is that a grandparent or grandparents could gift up to $17,000 or $34,000 for both of them into a 529 plan for their grandchild and not pay taxes on the income for that year. If you gift more than that amount, then the giver will have to pay a tax on the amount over the allowable $17,000 or $34,000 that they gave. But let's say that you can and want to pay a grandchild more than the allowable limit. The IRS will consider what the money was used for as part of the factors to determine if you'd owe money on the gift that you gave. If you gave money for vacations, cars, or weddings as example, it's a little bit harder for the IRS to allow this overage to be waived. But education costs or medical bills may be considered as allowable. If you're paying for tuition or health care, it's actually better to pay the amount over $17,000 directly to the institution that you're gifting on that recipient's behalf. It's interesting that if you're added to someone else's bank account, that is also considered a gift. The reason is that you now have access to the money, so if you're going to be helping a parent with their bills and they have assets of more than that limit, it's probably better to get a power of attorney to access their accounts to help them, but not be a joint owner. These gifts that are given do have a lifetime cap though. So if you give more than the $12.92 million in your lifetime, you're going to owe taxes on the overage amount as the person giving that gift. The taxes can be anywhere between 18 to 40% each year, depending on how much over that you've gone. But why would someone want to give away their money if they're still alive? For starters, it could be a real treat to see how your money is able to help those that you love with your truly meaningful gift while you're still alive. You can do this in many ways, but some of the most common ways include transferring the money directly into their account or adding them to an account that falls below the $17,000 limit. You could create a living trust that would allow you to access the funds if it turns out that you need them after all. You could also add them to a real estate deed that you have that's for property less than $17,000. Another option is just pay for things up to the limit. You could pay for their tuition, life insurance, or even vacations. Besides being able to see what the gifts that you've given have done for those that you've gifted, you'll also be helping them by possibly starting their college fund, helping them buy a home, or setting them up for financial security in the long run. But as for all of these examples, please contact an attorney to see which is best for you and your financial situation. With these gifts, you can share your knowledge of giving with others by encouraging gifting in your recipient and teaching them how to manage money for their future generations. You'll also be slowly reducing the size of your estate, which would lead to lower court costs and estate taxes. So when you pass, you'll leave more money to assign as you wish. Finally, you'll be able to take tax deductions now if your gifts are donated to tax-qualified charities. So what could go wrong? Well, it's possible to overgift and put yourself at risk for surprises like healthcare costs or other emergencies. You also don't get to decide how that gift is used. So if you can't give the money away and live with what they do with the money, it could put a strain on your relationship. If you think you'll be using Medicaid versus Medicare, they won't provide Medicaid services if you've given away money within the last 5 years. I can remember the difference between these two, Medicaid and Medicare, with the saying that Medicaid is for the underpaid and Medicare is for gray hair or old age. Lastly, there are tax and legal implications, so be certain to consult with a tax accountant or attorney that will specialize in these types of planning. Ask yourself, should you gift your inheritance before your death, or should you wait until after? There are many benefits that can bring you joy by doing this, but there are some downfalls, so you'll need to be keenly aware of each of them. Please leave what you're considering to do in the comments below. You don't have to be close to retirement to leave this information, just share which one sounds most appealing to you. Thanks so much for watching. Please subscribe and like, and then hit the announcement button so you get alerted when every new video comes out. This is Finances and with Kathy Pfeffer-Hahn. Thanks for watching.